Hello and welcome to Legal Angle, the policy roundtable where we discuss issues in the news
from a legal perspective.
Hey
Hi.
Matt, I'm Ken Parker. I'm here with my friend Matt Yaspin. Matt, how you been?
Really well, thanks, Ken. How about yourself?
Great. It's been a couple months since we did a show.
It has.
Things have happened.
Yes, busy time, and happily for us and those of our regular viewers and perhaps irregular viewers who are interested in what we talk about, there have been lots of things in the news that involve legal issues.
And I might even add to that, Matt, that this show, for those who have been trying to tune in to a new Legal Angle, is worth waiting for. Because we have got so much jam-packed into it. I mean, we better get started soon.
We should. Let's dive right
all
on
right.
in.
Okay, well, shall we take a look at the docket?
Yes.
Let's see if we can put that up on the
So
screen.
for tonight's show, we've got 5 issues.
Five topics.
5 topics.
Really?
Not just 5 issues.
And one of them has some subtopics. So
Yeah.
here we go. This is a lot of work here to get through all this. But so first we've got a copyright case.
A copyright case, yes, with some photos to illustrate the case.
Yeah, and it's really interesting because people make assumptions about Creative Commons, and we'll learn tonight that some of those assumptions about Creative Commons licenses are not entirely accurate.
Yes.
What do we have after that? We got
After that,
ninjas, sharks and
we
ninjas
have
and
sharks
robots.
and ninjas and robots.
Oh my!
What more exactly? What more could you want? In discussing this topic, we are going to follow something of a yellow brick road through the patent landscape
nice.
to see what they're talking about in this case.
And
what's up third, Ken?
Oh well, you know, so there is a federal agency called the FTC, and often people think, oh, they're regulating trade. What does that even mean? Well, they just came out with a sledgehammer of a decision. Some people don't think they even had authority to do. Others are celebrating it. They smashed every non-compete agreement in the country by a for-profit company. Nonprofits aren't within their jurisdiction. Got rid of them. So that'll be really interesting to,
That's a big
to
change.
look at that.
That's a big change.
And then fourth, we're going to the park.
Yes, that's right. Both the ballpark and the national park. There's,
Oh, look at that at the same time.
At the same
That's a
time.
great weekend right there.
It is.
A baseball game and a hike
It
in a
is.
national park.
well, as you'll see, if you go to a ball game at this particular park, which is a long ways from here, you wouldn't be all that far from some really nice national parks. We'll get to that in a moment.
I can't wait.
Yeah.
And then we'll discuss maybe 4 different Supreme Court decisions.
Yeah.
And possibly also another issue that casts its dark shadow over everything the Supreme Court does.
Yes, ethics.
You mean they have some?
Well, it's an
They have a
issue.
code.
It's an issue, Ken.
All right. Well, without further ado, I want to ask you about this first topic, Matt, if I may.
Sure. So copyright.
Yeah. So let me just frame it with. There's 2 lovely pictures on the screen here.
Yes.
And they're of this gentleman named Ted Nugent, and there was as I understand it, a Creative Commons. Oh wait, are you asking me about this?
I'm asking you about this one.
Sorry. Well, let's.
That's okay.
Yeah.
So
okay.
as any astute observer will know, these 2 photos that you see on the screen look a lot like each other. And that's because they are the same photo, but one of them was cropped. The one on the left, and you can see there's a whole lines of text under
Yeah,
it.
I don't know if our audience can read it. So it says photo credit Larry Philpott of www.soundstagephotography.com. This work is licensed under the Creative Commons, so on and so forth.
Right.
Disclaimer,
Right.
link, all that.
And interestingly, that photo, which I took off of the Wiki Commons, comes with a disclaimer, which you can read if you have got a magnifying glass out, that
I can read it from here, and my vision's not that great.
Larry
but it's blowing
Philpott's,
up.
well, you and I, yes, but if you're
audience
watching this on a
can.
TV screen, Larry Philpott sued users of this work for minor attribution errors. Keep the attribution intact. Hey, that's good advice. So, Ken, tell us about that. What happened here? Why are these 2 photos up and they look alike?
So here's the funny thing. Often a client will ask me, they'll say, Ken, I want to put some photos on my website. Where can I get photos? and they'll say, why don't I just use some Creative Commons photos? And sometimes they'll say the same thing if they're programmers. They want to use some Creative Commons licensed software code because they're like, hey, it's in this repository, it's easy to use, the code does what I want. And I often say to them, I hate to be the cloud at your picnic, but there might be some issues with using that photo or that software code or whatever other thing that's licensed Creative Commons, because a Creative Commons license is a contract. And when you use that picture, you're essentially signing on to the agreement. You get to use it only if you agree to the terms of the license.
Right.
And people will be like, and it's funny because even on the article that we saw about this, people were in the comments are like, "What's the big deal?" They posted that to Creative Commons, and this guy didn't, and the guy used it. So what did he expect? What did Mr. Philpott expect? Well, what he expected was his contract to be honored. He's not asking for a lot. He's not asking for money. He's not asking for a link to his website or commercial value. He's asking for under the terms of his license. He's asking for a credit and a link back to the Creative Commons license. He's asking for that image not to be cropped, in other words.
Yeah, I mean, there's other ways to provide attribution of the image, but yes, that's what he wants. He wants credit so that people seeing the photo
know that he was there and he took that.
Right, know that he took it and might check out the rest of his work. There might be some value to him and all of that.
Yeah, it's just they say, that's a fine photo, and this guy's a photographer, so
Right.
maybe it has some value.
Some value to him.
But
and even if it doesn't, even if it has no value to him,
I'm not a photographer. If I put something on Creative
those are
Commons,
still the terms under which
Right.
he let everybody use the photo.
So here's what happened though is the first court to look at this said, hey, you know what? It's fair use. So here's what happened is a magazine used this. The Independent Journal Review published Philpott's Creative Commons photo of Ted Nugent in an article titled 15 Signs Your Daddy Was a Conservative, under the fifth sign, which was that, quote, he hearts the Nuge. But
That's Ted Nugent, obviously, for
so
anybody who doesn't know.
Yes, and so they linked that, but not to the Creative Commons license.
Right.
They linked it to the Ted Nugent Wikipedia page, and they cut off the bottom part of that. And so the trial judge said, oh, well, this looks like a fair use of the photo because it's transformative, which is under fair use, you have to be using something for a different purpose. I do not see for it to be transformative. I don't see how photos are used in journalism, used with articles. It's bizarre. Frankly, it's bizarre to say that.
So I understand that if you're publishing a newspaper, a magazine, a website reporting on news, you might want to crop a photo just to make it fit better with the layout you have.
Right.
But the judge really said that crop that just
it wasn't the
crops
crop; it was the usage of it. It was because transformative use means you're using it for a different purpose. You're using it to comment on it, for parody, for something else, right?
But just using it to highlight the guy they talked about in their listicle article.
It was
Really? He said that was transformative?
Yeah,
okay.
yeah. No, so that didn't hold water. I think the judge was basically saying, what's the big deal? But the judge wasn't going to go where the commenter on the article went and make the ridiculous argument that the contract could be ignored. So the judge tried to find another way to say this was an infringement when Mr. Philpott sued the Independent Journal. But when this got to the appellate level, the court said, no, that's contract breach, and Mr. Philpott's not getting paid for the use of his photo. His consideration under the contract is the link, and darn it, that is a solid contractual obligation.
Right.
And so he won, and won statutory damages, I believe, of win a considerable amount of money. So the moral of the story, I think, Matt, is when we talk to our clients and our friends who have websites, be very careful about what pictures you put on your website. I mean, I got to say, I probably hear one of these about every week. Someone is being sued or getting a demand letter, often for thousands of dollars, sometimes for many thousands of dollars, for putting pictures on their website that they didn't have permission to use.
Yeah.
And the key here is just because it says Creative Commons doesn't mean you can use it. Now, you might be able to. it may say, and there can be a lot of things Creative Commons licenses can require, of course, right?
Right. Right, and I'm sure you've seen this too, but there are ways that you can use Creative Commons images and build into your website like plugins that automatically provide a link back. But sometimes the server software breaks, or your web
Right.
hosting platform breaks those plugins, and then suddenly you might be out of compliance with the Creative Commons license
Right.
by no longer providing that attribution, that link back to the Creative Commons
The
license.
other thing about a Creative Commons license is because they're all different, you basically need to read it. You need to have and the cost of having a lawyer read the Creative Commons license and say, oh, in clause 14 it says you can only use it for 1 year continuously or something. I mean, and there are Creative Commons licenses that say all kinds of things
Right,
like that,
right.
which is why we generally say unless you want to have a lawyer review, unless you really, really need that photo and want to hire a lawyer to review the contract, you're better off either buying the rights to use a photo, and there are many websites that let you do that, or get a photo that is truly in the public domain.
Right.
Rather than you relying on your interpretation of a contract. I mean, there are all kinds of things that these licenses say
Right.
that are easily violated.
Yeah. Plus, if you're using multiple photos from multiple sources, and you have to review or have your lawyer review multiple Creative Commons
Right.
licenses,
It's a lot of work.
prohibitively expensive.
Right.
It's just not worth the
yeah,
effort required.
And again, unless it's the only way you could get a photo of Ted Nugent, if that was the only one out there, then you'd want your
Right.
lawyer to review it, right? But
Sure.
But if
In the 30 seconds of research I did on that photo, there are many other photos of
yeah,
Ted
and I'm
Nugent.
sure that there are some that you could probably I'm sure you could buy very cheaply
Right.
a license, get a subscription to one of these services, gives you lots of access to photos.
Right.
Even then, of course, you've got to keep your subscription live while you're using those on a website.
It depends whether you subscribe,
Right.
whether you buy a perpetual license outright.
Exactly. You can buy. There's some licenses where once you download something, you can use it in perpetuity. But got to know the terms of your
Right.
subscription.
Talk to your lawyer.
Yes. Well, yeah. But
Fascinating topic.
yeah. No. I mean,
it's
in a way,
so
it's
easy.
obvious, right? But people don't know, and people.
Yeah.
I just had one of these calls last week. Someone got one of these letters, and it's wait a second. They put that on. It was on. I found it on the web. What's the big deal?
It feels like that's the start to so many tragic fairy tales now. I found
Yeah.
it on the web.
Well, I mean, again, and as our viewers probably know, because we've talked about this before, willful infringement of a copyright, just one photo, it's up to $150,000 in damages, plus attorney's fees. That doesn't always happen.
But it's possible.
It can.
It's possible.
Yeah, so,
Talk to your attorneys, folks.
yeah, right. Certainly don't use other people's stuff unless you talk to an attorney first. Anyway. All right. Well, Matt, I'm going to ask you. We've talked copyright law. Let's talk some patent law. You're a patent lawyer.
I am.
So, and I mean, my expertise in this is solely that I have an iRobot Roomba. So, and its name is Stanley, by the way. Stanley cleans mostly the first floor of my house. Does a fine job until he gets stuck in a corner and screams for help. But other than that, we want to know whether this this topic.
Now, I hope our viewers will forgive us for the title that we chose for this topic, Shark Ninja versus Roomba.
Yeah.
Which sucks more? Because that is really the core of this topic.
Well, which one brushes more? So yeah. So
Which one sucks more effectively?
okay. So let me frame it and then tell us what happened.
Sure.
iRobot, I think, was the pioneer in these home little robots. They've been making them for many years. I've had them since the very first model. I love these things. They're cute, they're entertaining,
Yep.
and they actually do a decent job of cleaning your floor. There have been many competitors since, one of which is Shark Ninja, and they have been in various lawsuits back and forth, I think,
Yep.
with iRobot. And so it looks like Shark Ninja said iRobot got a patent for one of their brush designs.
Yep.
And Shark Ninja went to get that patent canceled essentially in an what is IPR action? Is it
Yes,
called?
that's right.
So they get they post grant review of some kind, and they said that patent should never have been granted. Get rid of it. How are they saying this, Matt?
So-
did they win? Should they win?
Yeah, so what happened here is after iRobot had gotten this one particular patent issued, and they have many on different aspects of the mechanism of these little robots that drive around and vacuum stuff up. They'd gotten this particular one issued in 2009, and after that, they sued SharkNinja and also filed with the ITC to stop the
We
importation.
should tell our audience what ITC
Oh,
stands
please,
for.
yeah.
International Trade Commission.
Yes, thank you. So it's an organization that, among other things, can, in a trial type proceeding, let you stop someone from importing infringing products. That's what iRobot was trying to do here. Stop forgive me, stop SharkNinja from importing little robot vacuums that infringe. And you can see I put up a couple of the drawings here. The one on the top that's labeled US 7571511, that's the iRobot patent. That's
Oh, the 511 patent.
the 511 patent, as attorneys and judges abbreviate it in filings. They generally refer to just the last 3 digits. Hopefully they're unique and different
Within
from...
that case, yeah.
Right, within that case. They usually are, your odds are good.
1 in 1,000.
Something like that. A little less than that if there's multiple.
Good point.
But if you look closely at this drawing, what you'll see is there's this lateral brush kind of running between the wheels.
So which is that top one?
The top one is the iRobot one.
Okay.
So the things that are labeled 92 and 88 and 94 and that are running left to right through the center, that's the main brush that sweeps stuff up.
So I don't know if people can see what you're. Yeah.
I can't quite reach
no,
it from my seat.
So what you're
but-
saying is right in the middle, that horizontal line, though.
Yeah, the collection of horizontal lines that have got little things sticking up and down off them, those are the bristles. Okay, that's part of the main brush assembly.
Yep.
The two
I
things
know
to
it
the left
well.
and
I
right
pop
of it,
it out and clean it. And
excellent, are the wheels. And the thing that's labeled 70 at the top left of this drawing, you see there's 70 with an arrow pointing to that thing, and it's got kind of a curvy line like that with a
Yeah, and it's
circle
got
in the middle.
78 at one end and 78 at the other end.
So
that's the spinning
That's,
little brush that
that's
goes
a
onto the
side brush.
Yes.
iRobot's patent says we've got this main brush, which is entirely within the housing. The housing is, as you look at the thing that a cat likes to ride around on.
Right.
The shell of it.
Right.
You've all seen those
You
videos,
cannot, in
right?
other words, from above, you cannot see that main brush. It's
no,
all
no.
underneath.
This is a view from underneath. This
Right.
is what your floor sees.
That's the distinguishing characteristic
Yeah.
is it doesn't protrude from the sides at all.
That's right. The main brush in the iRobot patent here doesn't protrude from the sides. It's entirely within the housing. The housing
Okay.
is the big circles.
And
at
it's
the
got that
outside.
bonus spinny brush on the
And
side.
it's got that bonus spinny brush that sticks out to the side. Okay.
Yep.
Now, SharkNinja filed this IPR. It's an acronym that stands for Inter Partes Review. After someone gets a patent issued, you can try to get it invalidated by saying there are things that the patent office should have taken into consideration. That's what SharkNinja did in response to the lawsuits and the ITC action.
So this is kind of a preemptive strike because SharkNinja doesn't want to be sued, presumably.
I would say post-emptive because they've already been sued.
They're
And-
like, get rid of that patent.
Right. And their response is to try to say, well, you shouldn't be able to sue
You
us.
can't sue us for infringing a patent that shouldn't have been granted in the first place.
That's what SharkNinja is trying to do.
Okay.
They're trying to take away the patent that's being used to cudgel them.
Yes.
What they do to do that is find 2 other patents, and I've got an image from one of them up on the screen. And they say because of these other patents, iRobot's patent should never have been issued because it was obvious. And I'll explain what that means in one sec.
First, walk us through that bottom picture. That's the
Yeah.
SharkNinja?
No, SharkNinja doesn't have a patent. They don't have a horse in this race. They found patents by 2 other parties.
So what's that bottom picture there then?
That's a Dyson patent.
Ah.
Dyson, another vacuum
Yes.
maker. It's referred to in the Court of Appeals for Federal Circuit decision as the Bissett, I believe. But that's the inventor's name.
Okay.
Dyson is the company.
Yes.
Okay. In the Dyson patent, which is the one at the bottom right of your screen, it's got main brushes that extend past the edge of the main housing. The main housing is the big circular thing.
Yes.
So you see here, I can almost reach it. The brush, that's this here.
Extends, but that's the brush that's spinning this way. They don't have one that's spinning that way.
They don't, that's right.
So far, I'm not convinced that.
Okay, but hang on
teaches
one
that.
second.
All right.
Because this is Shark Ninja's attempt to make an obviousness case.
Ah.
And in an obviousness case, you say whether it's the office, the examining attorney, an examination, or the PTAB, or in a court, an obvious case consists of somebody saying, this already existed in the world, say my phone, okay? And this already existed in the world, this is a pen.
PTAB meaning Patent Trial and Appeal Board?
Yes, thank you, Ken. Sorry.
I know, we're talking lingo all
I'm
day
getting
long.
excited here.
I know.
So say you've got, now my phone and my pen are probably a bad example, but say you've got a stool with no back and a chair
With a back.
with a back.
Got it.
But the chair, for some reason, has no legs. I don't know why. It's like one of those.
Oh, it's a hovering chair. I love those.
It's better, Ken. I've got it. It's one of those Crazy Creek folding chairs.
Okay.
You know, those hiking chairs.
Okay.
They don't have any legs, but they have a back. Someone's got a stool, but it doesn't have a back. Well,
It's obvious to combine those
obviousness
features.
is this legal standard in patent examination that says, you know, this thing was known and this thing was known. And so at the time that somebody invented this over here is a chair in my example, it would have been obvious to anyone who knew what they were doing in chair making.
Who is skilled in the art, in other words.
Yes, to put together the stool without a back and the chair without legs and come up with a chair with legs and a back, like I'm sitting in.
Ironically, this is the opposite side you're usually on, right? When you're trying to get a patent approved, you're usually saying, that's not obvious.
Or, well, it depends what we're
Right.
trying to do. But yeah, obviousness is something that you always want to consider when you're either writing a patent or assessing whether you can make or build something. So here, what we've got on the bottom is an image of this pre-existing Dyson patent
Okay.
that's got a brush sticking off to the side. What I don't have an image of, because I couldn't find it, is the second patent that Shark Ninja dug up to somebody named Toyota. Sounds like the car company, but spelled with a D.
Okay.
At the last T.
Okay.
That one, according to the decision, has got multiple spinny brushes.
Ah, horizontally spin. Okay.
Yeah. So, Shark Ninja is arguing that
You could take the spinny brush from that one and the protrusion from the other one.
That's right. Shark Ninja is saying, look, the Dyson patent with its main brush that sticks out past the edge of the housing and Toyota's patent with multiple spinny brushes are obvious, and it would have been easy for anybody to take the main rotor, which in the iRobot patent is entirely within the housing, and extend it beyond the edge of the housing. Now, iRobot didn't do that, but they've got a little other brush that's out beyond the edge of the housing.
So what did the court say about this, Matt?
The court said, Shark Ninja, what are you doing? This makes no sense. Because on the obviousness question, the iRobot patent says that the main brush has to be entirely within. It doesn't use the word entirely, but it talks about within. And the brush, as you can see, sits in a cavity, essentially,
Yes.
inside the housing. That cavity is within the housing. Therefore, it's incorrect to say that the iRobot patent is inspired by this other Dyson patent where the main rotor extends beyond the edge of the housing. And it's not obvious to combine the Dyson one with the rotor extending beyond and pull that rotor
So Shark
back
Ninja
inside.
lost, and iRobot gets to keep its patent and presumably sue Shark Ninja for infringing its patent if Shark Ninja
Yes.
is doing something similar to that top thing.
That's the outcome.
Interesting stuff, and it makes sense too. I mean,
Yeah.
sounds like this court did a good job. Right? This is the
This is the
Fed
court-
Circuit, the Court of Appeals for
Right.
the Fed Circuit, which is in Washington D.C., and is the first line of defense or appeal for patent cases.
It's where all the patent cases go because
no matter where they come from, anywhere in the country.
because everybody, including eventually Congress, got tired of patent decisions from trial courts, federal trial courts, being appealed to circuit courts
all over the country, right?
where nobody understood anything, and instead the CAFC has people who understand patent law.
Right, and so they go to the First Circuit, they go to the Fed Circuit, which understands patent law, but there's still one more appeal after that to the Supreme Court, which doesn't understand patent law, and that's where you get decisions like Alice from.
It's like we've spoken about this before. Yeah, or Ariosa, which just make no sense at all. But that's what happens if someone loses at the Court of Appeals for the Federal Circuit and doesn't like it. They appeal, it goes to the Supreme Court, where everything gets messed up.
Fortunately, the Supreme Court doesn't take a lot of patent cases, so they don't mess them up that often.
One of my favorite lines from the Supreme Court was not about a patent case, but it involved science. And the late Justice Scalia commented, as a joke, I think, during an oral argument. It was the Massachusetts versus EPA case.
Ah, yes, standing. Very important case.
It's about standing, but to understand the facts, you had to explain some of the science of atmospheric dynamics. And Scalia comments, troposphere, stratosphere. To be honest, that's why I didn't want to take this case. Ha 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 ha.
Well, it's
how funny. Funny that a judge says on the record in oral argument
that he doesn't get science,
that he doesn't understand what the parties are talking about.
Well,
not that he doesn't care about it. He just doesn't understand.
Yeah.
And then he gets to go and make a decision based on the facts.
Well, one hopes that at least some of the 9 justices get the facts, but
none of them have any science or engineering background,
Right.
and to my knowledge, no judge, no justice of the Supreme Court has ever had any science or engineering background. The closest we've had is an economics major.
Hopefully they have people working for them who are good at explaining things, who have the requisite backgrounds, but who knows? I will tell you, though, that is a case I spent way too much time studying because I did a Pace Environmental Moot Court in law school, and that was one of the important cases that we were arguing. So, man, standing. You're bringing back nightmares of late night moot sessions.
Good times, man.
Yeah, anyway,
Good
all right.
times.
I think before we get to our Supreme Court cases, don't we have another topic? Let's
We do. We've got 2 more.
Yes,
so
right.
next up is...
Let's play ball. Or is that next?
Not yet.
Not yet.
Hold your horses.
Okay.
Rough Riders.
I'm leading too far off the bag.
Yeah, yeah. Wait for it. So the next up is the Federal Trade Commission and non-competes.
Oh, so you have some questions for me about
I have
this.
questions for you. First off, what does the Federal Trade Commission do?
Funny you should ask, Matt. So of course we have a lot of, we have the deep state in this country, as you know, right? It's federal agency. So we've got the Environmental Protection Agency. They say, please don't put all that toxin in the water. They issue regulations. Maybe, so these various federal agencies are issuing different regulations about how to do things. You've got the Securities and Exchange Commission for securities trading, buying and selling stocks, and you can't market stocks in a certain way that deceives people. You need to disclose a lot of information. The Federal Trade Commission is the federal agency. I think this isn't too obscure. Most of our audience probably knows this, that regulates commerce, essentially, that regulates businesses doing deals, and they issue regulations for what would be deceptive business practices, that sort of thing. They only have for-profit businesses within their jurisdiction. Spoiler alert. Not nonprofits,
not community organizations, not churches.
Yeah. So if you are a nonprofit charity, it has to be a truly charitable organization, not something that's engaging in commerce, that calls itself, you can be a not-for-profit that engages in commercial activity and still be regulated by them. But, and we'll get to in a minute why this is so important. But every for-profit company in the country is regulated by them. And they have, under the Supremacy Clause of the United States Constitution, the federal government's laws and regulations trump the state government laws and regulations. They can occupy the field, or they can just say on a case-by-case basis, we're going to preempt. So there's lots of different state laws, and there have been for years, about non-competition agreements. It says, Matt, you work for me. You have to sign a non-compete that says after you leave my company, you're not going to work for any of my competitors for 2 years. That was very common, especially for higher level jobs in most states, until some states said, well, you're not really letting Matt earn a living, Ken. If you do that to Matt after he leaves, you're kind of controlling him, and you're actually, that's not competitive. You want a competitive marketplace where everyone's skills.
I mean, that's the name of the clause, right? Or
Right.
the contract, non-compete, don't
Right.
compete, you can't
Right.
compete.
Right, and so, but I mean, it's also the name of the FTC, in terms of, trade, right? You want to
Right.
have
Right.
free trade. Well, it doesn't say free trade; it's federal trade. But what they're trying to do is avoid monopolistic practices, and so. But a lot of states already kind of caught on to this. California was, I think, the first to totally ban non-competition agreements. You just can't do it. You cannot freeze somebody out of working wherever they want when they're done working for you.
Right.
Other states took a softer approach, and they said, well, you can have non-competition agreements, but only for higher level executives or people with equity, or there were like limited realms of who could do it. You also had in Massachusetts for many years we had a geographic limitation. So
Meaning that you could
ban
stop people
people
from
in-
competing like from a radius around where your
exactly, and it was
business
literally like if you're in Boston, you could have a non-compete that stopped other people, other companies in Boston from hiring your former employee,
But if you
not
wanted to
go
locate
to
in
Worcester or
Worcester,
somewhere,
sure.
somewhere farther away, that would be fine. There were also non-competes. You can't stop them from having any job at your competitor, only the same thing they were doing.
Okay.
There were all kinds of restrictions about that. And then there were two approaches to enforcing those restrictions. One was to totally invalidate the non-compete if it went beyond those things. And the other was to redline it or blue line it so that the judge could rewrite the non-compete to be compliant with the law. Like you said, Matt
Oh, I
can't
see.
work anywhere, but the judge will say, no, I'm going to blue line this to say Matt can't work within 50 miles. The other big constraint was duration. Massachusetts wouldn't enforce a non-compete of more than 2 years duration.
Okay.
But they could blue line a longer one down to 2 years.
And that's what they would do if it were written that you can't work for a competitor for a period of 3 years or 4 years.
They would say, no, 2 years is all you get. Some courts would say, totally throw it out, flush it down the toilet. You're asking for too much, you get nothing.
And some would allow the employer to modify the non-compete.
The
to
judge,
become-
it actually was judicially modified. But
Okay.
yeah, they
But
would whittle it down to what was legal. They'd cut off all the illegal parts. Or so there's the kill it if it's got any illegal parts, or the whittle it down if it's got illegal parts. So all these complicated different things. And so advising
Plus-
a client,
and-
every state was different, right?
Right, so it's a huge patchwork, and you'd have to consider, I imagine, both where the employee was and where the employer was and where
Right.
else the employer had offices.
One of my very first
Right.
cases after I became a lawyer was basically we were invalidating an employer's non-compete because they were trying to stop my client, who wasn't making a whole lot of money anyway, from working in the Boston area in the real estate field. And it was crazy because she needed to make a living.
Right.
And so we said, no, look at all the ridiculous levels of restriction. Also, the other thing, I think we ended up invalidating it because she wasn't given any consideration they added it on later. So you have to be paid something
for a
extra.
contract, yes.
Yeah, under contract formation. So there were all kinds of arguments. But the bottom line is, the Massachusetts legislature a few years ago said, wait a second, these things are anti-competitive, these
Okay,
non-competes.
so Ken, thank you for that overview. Now, I think I and our viewers have a firm grasp of what the landscape was for non-competes.
So what?
And what's happened now.
The FTC said, I don't care whether you're in California or Massachusetts or Nevada or Washington, D.C. or anywhere else in the United States of America, non-competes are gone as of June 1st, basically. So,
Just gone.
There it is. That's it. You're done.
Don't even try to enforce them.
You can't even sign new ones. Existing ones are kaput. Now here's where it gets really interesting, and what we were foreshadowing before, is that the non-competes that a lot of people object to, particularly in places that are medical a lot of medical facilities, are the ones that stop doctors and nurses from going to a competitor.
Right.
And it just so happens that a lot of hospitals and medical facilities are nonprofits, so they may be exempt from this rule.
Interesting.
Now the question is, are they engaging in commercial activity and therefore within the jurisdiction of the FTC? And this is probably going to be litigated soon if there is an attempt to enforce these against doctors and nurses. Now doctors and nurses in Massachusetts are probably okay, because what our legislature did a couple of years ago is they weakened our non-compete law to the point where, they strengthened they limited it, I should say, to saying you need something called garden leave. You basically have to pay someone not to work, and they limit it to 1 year duration, and they added a bunch of other things to it. So my firm, we've been advising employers for a long time, don't use non-competes. They're weak and not particularly useful. To protect your intellectual property, use trade secret protection and non-solicit agreements, which mean you can't ask, when you go to the new company, you can have, if you have a non-solicit, you can't go after the employees of your former employer, and you can't go after the customers or service providers if that's what the contract says. And that pretty much, so if you can protect your trade secrets, you can protect your people and the people you do work for you and the people you do work for, you're getting most of what you want out of that non-compete, but you're still letting the person make a living. So Massachusetts is not that badly affected by this. I mean, not
Because our non-competes were already very limited.
exactly,
Right.
but there are a lot of states where this is, if a business was relying on non-competes, they kind of did get the rug pulled out from under them. And there'll be a lot of lawsuits coming out of this. Obviously, I kid about the big state, but there are people who don't think agencies should have this much power and will argue that that Congress did not intend to give the Federal Trade Commission this much discretion.
No doubt. Well, that'll be, I'm sure, a topic for next fall as the lawsuits start.
Yeah, well,
pouring in.
we've got we'll definitely have to revisit
Yes,
this.
yes.
So I want to ask you now, Matt, about another interesting topic in the news. I believe it might be topic number 4. Here
Yeah.
it is. Okay,
Yeah.
so I love baseball, Matt.
Indeed, I know, and I do too. So why this headline? What's that mean?
Yeah, so there is a minor league baseball team that has a logo. There it is, the RR logo there.
Yeah.
And there is a federal agency with a logo, the National Park Service.
Yep.
Talking about federal agencies.
So-
So one sued the other. What's going on with this, Matt?
So it hasn't reached a lawsuit yet, but it's at an administrative trial stage. So what's happened here is that there's a relatively new, I believe it's a minor league team, or it's a league that's affiliated with Major League Baseball.
Yeah, it's independent.
I don't think
minor-
it's
like the North Woods League or one of those.
Pioneer.
Pioneer, yes.
Sticks in my mind. The Pioneer
Yeah.
League. I believe it's the Kalispell Range Riders,
Range Riders.
or the Glacier Range Riders, something like that. Yeah. So
Where are they, Matt?
in Montana.
Yes.
They're fairly near to Glacier National Park. Now, if you look at their logo, so I grabbed here, these are the trademark images.
The two on the upper right-hand corner there.
Yes.
The RR and the
So the 2 at the top are the ones that are in dispute. The 3 at the bottom, which are like a mountain goat holding a baseball bat and wearing a park ranger hat or something that looks like one, and then a mountain goat looking like he's swinging away or she is swinging away.
on top of a car or something.
No, the one in the middle, just
Oh, okay.
swinging
Oh, okay.
away, also wearing a park ranger hat. The one on the right is a bear, also holding a bat and wearing a hat, but riding.
Glacier Range Riders.
And it says Glacier Range Riders.
Those are not in dispute.
Riding in a bus of the sort that the Park Service used to use, maybe they still do use,
Okay.
for
So who
sticky,
initiated this?
sticky tourist
Who's starting
rides.
the fight?
So,
What are they
so these
complaining
3 on the
about?
bottom are not in dispute.
Okay.
They're all filed by the baseball team.
Okay.
The one on the top left that says RR inside an Arrowhead logo, also filed by the baseball team. That one's in dispute.
So
So what's happened here is
who's complaining?
the National Park Service is upset. They are complaining. The National Park Service has the logo at the top right. It's got an arrowhead shape with an outline of an arrowhead. It's got a giant sequoia tree. There's a snow-covered mountain. There's a bison in the foreground. It's got sort of a wood block print look to it.
Got that kind of rough edge. To
It's
it.
got a rough edge. It's an asymmetric arrowhead. That's a National Park Service registered trademark. It's registered for, among other things, clothing, because the Park Service sells a bunch of clothes, souvenirs.
Yes.
And it's registered for entertainment services, education.
Yeah.
Sure, those are things the Park Service
Class
does.
25 and 41.
That's right, respectively. And it's registered for other stuff too, and they've got other variations of the logo. The Range Riders, the baseball team,
Brand new baseball team.
fairly new, just a few years old,
They registered their trademark.
have
Is that all
applied
right?
to register their trademark, the RR inside of an arrowhead logo, for, among other things, clothing, that's in Class 25, same as the Park Service, and entertainment services, because they hold, guess what? Baseball games.
I find them very entertaining.
I do too. So, they filed it. The Park Service objected procedurally during the application, at a stage of the application when you're allowed to. The Park Service informed the USPTO, hey, we think this baseball team's logo is confusing. It's called a letter of protest. It's easy to file. It's a good procedural step. That way you're sure, the Park Service was sure, to bring to the attention of the USPTO examining attorney looking at the baseball team's logo application that the Park Service thinks it's confusing. The Park Service filed it. The USPTO disagreed. They then allowed the application to go forward to what's called the publication stage. And at that stage, anybody, and I mean anybody, anywhere in the world, can object to the application.
And send it to the TTAB, the Trademark Trials and Appeals Board.
Right. They file what's called an opposition to oppose the application from getting registered, and it went to the TTAB. That's where this application is now. The Park Service has filed their argument saying, we've got this logo, we've had it for a long time, we sell clothing, we have parks, in case you didn't know, and this baseball team is located near to one of our parks.
Let's
And the baseball team has filed their answer, and they say, no, it's not confusing. And P.S., Park Service, you filed a letter of protest. The examining attorney knew about your applications and still said, no, nobody's going to get confused.
Okay, Matt. First of all, why is the Park Service concerned about this? Are they arguing that people are going to think that baseball team is affiliated with Glacier National Park?
Yes.
Is that their concern?
Yes, that people are going to think that the baseball team is sponsored by the Park Service, or that people might be confused if they're trying to visit a park and go to the ballpark, or if people are trying to buy Park Service clothing and wind up buying baseball team clothing. They may also be concerned that the baseball team is somehow going to bring the Park Service and its parks into disrepute.
Because
tarnish
they'll think, oh, this baseball team's affiliated with Glacier National Park and their hot dogs are terrible. Therefore, the hot dogs in national parks are lousy.
Yeah, the hats they wear aren't Park Service hats, and people might go to the ball game and think, I thought these were park rangers playing baseball.
Right.
I'm not really sure.
So dilution, they're arguing maybe, or?
In likelihood of confusion, potential loss of revenue,
Right.
and dilution.
Okay.
Maybe tarnishment, although I don't think I saw that in their argument.
Okay, so bottom line is they're saying the Park Service says this is a problem, stop these guys from doing this.
Don't let them register this mark.
And what would the effect of that be, Matt, if they couldn't register?
So if the Park Service prevails, then the range riders won't be allowed to register their mark.
Can they still use it?
Well, they can, unless and until the Park Service stops them.
Like, for example, by suing them and saying,
That
you're
would be-
infringing our trademark.
Exactly. That would be the Park Service suing them. And it's even harder for me to imagine that happening and succeeding for the Park Service. But who knows, with enough money in litigation.
There's a story behind this
anything is
somewhere,
possible.
Matt. There's somebody who knows somebody personally.
Part of it is that when the baseball team launched, apparently someone either associated with the baseball team's organization or doing the marketing for them talked about the history of Glacier National Park, and that there were these folks who referred to themselves as range riders near the park, and they protected the land.
They were trying to play off of the theme.
They still are, because the phrase range riders refers to people who were in the area of
So
Glacier.
their gripe isn't really with that shape; it's with the narrative in a way.
Well, I think it's with both, but they've got very, very little grounds to oppose the applications for the goat in a hat, the second goat in a hat, the bear on a bus. They have, a colorable argument against this Arrowhead logo.
You're not buying it, Matt.
I'm not. And if we can flip to the next slide, I'll tell you exactly why I think this is.
And then give us some stats, because I think you have the stats.
You
came with numbers.
I brought receipts, Ken. I brought receipts. Okay, down here at the bottom of the slide now, you'll see, dear viewers, on the
Oh
screen,
my goodness, the same wavy edge.
It's not the same, but it's certainly an arrowhead shape.
But it's also not a smooth arrowhead.
It's the outline of an arrowhead shape. It's a wiggly and irregular arrowhead shape.
Matt, if I
hang on, I got more.
Yeah.
And it's got 2 letters inside it. If you don't recognize
But
it,
it's pointing
folks,
to the right instead of down.
If you don't recognize it, folks, it's got a lot of visual elements in common with both the Park Service logo and the Range Riders Arrowhead logo.
But might that be a football team logo?
It is, and it's located, closer to Glacier National Park than you and I are right now. It's still a fair ways away. It's in Kansas City.
Yeah,
That's the
I
Kansas
wouldn't
City
want to
Chiefs logo.
walk, but yeah.
It's a long walk. Here's the thing. The Park Service says, we've got an irregular arrowhead shape, but that's not their trademark. They don't have exclusive rights to the arrowhead trademark shape. Now, I went and looked because I was curious as I read this, and
that's what I was going to ask.
My first thought was the Kansas City Chiefs.
Is this common? There are a lot of arrowhead marks out there.
Let me just give you a 30-second background on trademarks. Trademarks can be words. They can also be pictures. They can be other things too. Video.
We talked about aromas one time.
One of my
favorites.
Jingles, shapes.
Anything that you can recognize.
Colors.
The source of a product in commerce, a brand.
Okay, that's right. When trademarks are pictures, the office codes them like a sort of Dewey Decimal System of images.
Circles, ovals, triangles.
Humans, letters, animals, whatever. There's levels of detail. Okay, there's one that is specifically for arrowheads.
Yes.
I don't have the numbers offhand for how many total records there are with it, but I looked.
I believe you told me there were 4,000 plus.
There's 4,000 and some that relate to arrowheads and are in use or were applied for with either stuff in Class 25, which includes clothing, although not necessarily, that is only clothing, and Class 41, which includes education and entertainment. Those 2 classes in particular because that's what the Park Service and the baseball team do. And even if you narrow it down to ones that are registered and ones that are active, there's still several hundred in each of those classes, and there's 50 some, if my memory serves, 50 some that are registered and active and in use with both clothing, Class 25, and something in Class 41.
So the bottom line is the Trademark Trial and Appeals Board, where they're suing. I use the word sue loosely. It's not a court.
I understand it's not a court. It's not a lawsuit.
But where they're fighting it out with legal motions and whatnot.
Yes.
And they do follow similar rules of procedure to courts.
It's a legal fight. It's a trial.
No, we've done a bunch of them. So and some involving letters and logos. In fact.
Yep.
They're not going to win this. The Park Service doesn't have much of a chance.
I don't see how they do. I mean, their argument is just that this baseball team has got a wiggly arrowhead shape.
I mean, I think the only way that they have a plausible argument is by taking in elements of they can argue likelihood of confusion based on these external factors about where they're located and this other narrative, but I don't think that's going to carry the day.
Yeah.
If it's even allowed. I mean, some of that they may exclude some of that evidence anyway.
Yeah.
But even if it's allowed, I'm just trying to imagine Joe Public. If they would need basically to do a survey. That'd be they'd have to show some actual confusion, like people thought they were going to that they were sponsored by the Park Service. I think it's that hard to imagine.
It doesn't seem like a strong argument to me. I don't work for the National Park Service.
I go to a lot of national parks. I've been to.
I do too. I love them. I'm glad they're doing it. I'm not really sure why they're going after this. And in fact, I started to see it looks like it might become a bit of a political hot potato. There's a congressman from Montana who was grilling the Interior Secretary,
Yeah.
Deb Haaland, about why the Park Service is enforcing this. And I'm inclined to agree. I'm not really sure why they're trying to
Yeah,
enforce
it's
this.
probably not the best use of resources or goodwill, for that matter.
I just don't think it's
Oh,
a
look,
great
the
argument.
Supreme Court.
All right. Now, if any of the topics we've talked about so far today get appealed and appealed and appealed, where are they going, Ken?
SCOTUS.
That's right. What are we going to talk about next?
Well, I want to ask you, because I want an update, Matt,
Hmm.
from you. Remember we talked, oh gosh, or actually, yeah, we talked maybe a year ago or something. The Supreme Court came out with their ethics guidelines.
Wasn't that long ago. It was. They came out with it last November, so we must have talked about this.
2023.
Probably in our November show.
Okay, and it was news at the time. We were talking about
It was
an issue in the news.
No,
and here's
I've got a copy of it here.
before we're going to talk about 4 recent Supreme Court decisions briefly, because
And we're going to do it fast.
But before we get into them, I want a 30-second update from you, Matt, on how is the Supreme Court doing with that nice new shiny code of ethics?
Oh, do you need more details?
Other than the maniacal laugh, yes. A few words of explanation.
I would like to direct your attention first to Canon 2, Section B.
Wait, Canon 2?
So the Code of
It
Ethics
sounds like a religious document.
is, well, it's funny you say that, is laid out with numbered canons. So 2B starts, I know. 2B starts with, a justice should not allow family, social, political, financial, or other relationships to influence official conduct or judgment. Okay, great.
What is the issue you're trying to flag here, Matt?
It's just, let's not just flap in the breeze. Let's get to the point. Canon 5, titled, A Justice Should Refrain from Political Activity.
Oh gosh, you mean the Supreme Court justices can't be involved in political activity?
That's what it says. A justice should
What
not.
happens if they do? What's the penalty?
Hold that thought, Ken. That's a great question. A justice should not publicly endorse or oppose a candidate for public office. A justice should not engage in other political activity. Okay, that was November 13th.
Not that long ago.
Not all that long ago. I bet the justices remember this happening also. You asked
You
about...
would think if they were at a code of ethics, they ought to commit it to memory, or at least be aware of its existence.
I mean, it's pretty easy to find online. So
They ought to know that they have
what
some
happens?
rules. Yes, right.
Nothing. There's no enforcement mechanism. It just says the justices should recuse themselves.
And if they don't?
Nothing happens.
And have any Supreme Court justices been involved in political activity since, I don't know, January 6th? Just to pick a random date.
Well, before our energy for this topic flags, Ken,
You're in pole position now, so why don't you?
let's test this. Let's run it up the flagpole and see.
Why don't we turn it upside down and inside out?
So what's happened is that Justice Samuel Alito has been found to have flown several flags, at least 2 that we know of, at 2 of his homes on occasions that are tied to
The insurrectionists.
the traitors who attempted a coup on January 6th of 2021. And in the couple weeks after that attempted coup, Justice Alito, at his home, flew the American flag upside down. Now,
what's the significance of that?
Anyone who's a mariner knows that means I'm in distress. You know, if you're on a ship and you've lost power at sea, turn the flag upside down. It says I'm in distress.
And when was that recently used in a political context?
Well, on January 6th, in fact, it was used by a lot of the traitors who rioted and attacked the Capitol and attacked policemen, because they were saying that the country is in distress because Biden has been elected, or in their lie-filled telling, Biden stole the election, which is not true. Okay, Alito flew that flag at his home. He said when it was discovered, actually it was my wife who flew it, and she
Blame
had
the wife. That's always a good line.
It's such a bad look. And whether it's true or not, it doesn't matter. Now, under these ethical
Creates
guidelines,
an appearance of.
under these ethical guidelines, did he do anything wrong? maybe not, because they didn't have any ethical guidelines until last fall. But under any reasonable interpretation, including the preface to these guidelines, which says we've always had ethical guidelines, we just didn't write them down.
Right.
Did he do anything wrong? Absolutely. He aligned himself and he allowed
Are there any cases
his.
relating to this January 6th that are before the court? And if
Oh.
so, has he recused himself?
It's funny you ask. There are, in fact, cases about January 6th coming up, both various of the traitors and also Donald Trump. And no, he has not recused himself. And in case you thought, well, it's only one time and that flag was only up for maybe a few days.
He didn't have another flag.
And then it was up again on Biden's inauguration day, but whatever. There was just the one time, actually, at their summer home in New Jersey, I believe on the Jersey Shore. They flew another flag, which is a Christian nationalist, now adopted as a Christian nationalist flag, flown by several at the insurrection, that Alito flew at his house for.
But he didn't put it. Was it his dog who put it up? I mean, or maybe a pet with opposable thumbs.
I don't think he.
Is he blaming? Who's he scapegoating?
I don't know. Maybe that goat with the bat from the trademark
There's a
applications.
goat hold the bat for that matter. No opposable thumb.
Again, these are enduring mysteries, Ken. It's pretty astounding to me that so far he hasn't recused himself. He's flown 2 treasonous flags at 2 of his homes on multiple occasions,
All right.
and he's not recused himself.
Okay, we have 4 minutes and 4 Supreme Court cases. Can we do it? Let's
Sure.
let's try to get through them.
Here we
All
go.
right. First of all, the Supreme Court ruled that South Carolina Republicans can use the gerrymandered map they came up with, and even though it discriminates against African Americans and disproportionately crams them into one district where they'd otherwise have 2 seats. Matt, do you know why the Supreme Court said it was okay?
Yes, I do. May I say?
Sure.
It's because the Supreme Court said South Carolina didn't do this because they're black. They discriminated against them because they're Democrats.
Yeah, so-
and that's okay
Right.
for the South Carolina Republican-controlled
Yeah,
legislature
so
to do.
so discriminating against African Americans is fine as long as you're doing it for political reasons.
Right.
I guess that would apply to sexism, racism of all kinds. I mean, that pretty much does away with most civil rights laws if you're allowed to. I mean, like, I don't like you could have, like, imagine in a southern city where there's most of the African American population is black. Why they could say no Democrats in my restaurant? How would that be any different? And that would keep most of the, I'm going to check the voter.
As far as Samuel Alito is concerned, that would comport with our nation's long-held history, so it should be fine for him.
Yeah.
Okay, moving on.
Okay.
Next up, in Louisiana, we reached the opposite outcome, right? In another districting case where Louisiana could not implement their plan to do away with 2 majority black and majority Democratic districts, but not because doing
Right.
so would be discriminatory for any reason at all. It's because it was too close to the
It was
election.
inconvenient.
It was too close to make a change.
Right.
So don't worry, Louisiana.
You'll get to discriminate soon enough if
Right.
Alito has his way.
Right. Well, for the next election, you can.
Well, Alito dissented in that anyway, right? I mean, there were 2 dissents. I believe that was actually.
Well, did he dissent because he thought they should be able to just change the maps anyhow, even though it's right before the election? I don't have a whole lot of confidence in Samuel Alito.
Yeah, no. I'm saying he dissented. He was being consistent that he thinks they should be able to discriminate at any time they want.
Oh, good for him. How great that he's consistent. Okay, Ken, you know what? I think we got to wrap up. I don't think we can get to the Consumer Financial Protection Bureau.
Yeah, that's a little
except
more
to say
complicated.
It can still exist.
Well, yeah. Well,
We'll revisit this.
but we got to talk about Warner Chappell Music, the copyright case, next show.
Next show.
Because that's a juicy one. I really want to talk some copyright. Well, Matt, that was quick.
An hour flies by, Ken.
Yeah, well,
always a
thanks
pleasure.
very much, and thank you at home for watching. Matt, do you think we should get together again next month to discuss issues in the news?
From a legal perspective, I would love to.
It'll be great. Might actually have to be a little, not the last week of the month. We'll find a time, but
We'll flag it.
thank you. We will, of course, be joined once again by our fabulous crew. And tonight, our director was Will. Will, great job. Thank you so much.
And thank you to Kathleen. We really appreciate it. Couldn't do it without you.
And
thank you, folks.
And we'll see you again next time when we try to find, we do discuss issues in the news.
From a legal perspective.
Night.
Good night.